Hello, everybody, and welcome to History/Law Bite number 291, dated July 22nd, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you for tuning in. Before I get into this video, however, I have one simple request. I ask that you please subscribe to my YouTube channel, Juarez Lee Shelton, MA, and click on that little indicator bell next to the red subscribe button. In doing so, you will receive notifications whenever I post new videos so you can watch more and more of this ever so exciting historical, legal, political, theological, and philosophical content. Thanks in advance. This History/Law Bite is entitled The Quock Walker Case, 1781. So the Quock Walker case, which was actually three separate cases, okay, all based upon the same, original event, all right, was one of two very important freedom suits in the Commonwealth of Massachusetts, okay, that eventually led to the destruction of all support for slavery in the state, in the legal sense anyway. All right? This case, the Quock Walker case, along with Brom Bett versus Ashley, which is covered in a separate video, destroyed virtually all legal support for the institution of slavery in the Commonwealth of Massachusetts. So, like I said, for the record, these two cases brought about the essential destruction of slavery in Massachusetts, okay? And Massachusetts thus became the very first American state to do away with the institution of slavery. If you didn't know that, now you know, okay? By 1783 to 85, all right, Massachusetts had all but done away with the peculiar institution, thanks in large part to the Quock Walker case, as well as Brom Bett versus Ashley, again covered in another video, okay? Additionally, Massachusetts was the only state to do away with slavery virtually by way of litigation. All right. In most other states, it was done by a state constitutional amendment or by a legislative enactment. All right, of some sort. But in Massachusetts, it was done essentially by way of freedom suits, which is a beautiful thing, ladies and gentlemen. Freedom suits. If you're unaware what those were, freedom suits were lawsuits brought by enslaved persons or brought on behalf of enslaved persons in order to obtain the freedom, okay, of those enslaved persons from an otherwise resistant master, okay? Now, Quock Walker, in his case, okay, resulted in a landmark decision from the Supreme Judicial Court of Massachusetts, which of course is the state Supreme Court, and that decision essentially gave us the principle that slavery was incompatible with the state constitution. That would be the Constitution of 1780, all right? Which, by the way, is the Constitution that Massachusetts is still operating under to this very day. Why, you ask? Well, Massachusetts' Constitution was written by none other than John Adams, a very prominent American founding father, of course, my favorite founding father, an outspoken opponent of slavery, the first vice president of the United States, and the second president of the United States. Adams deliberately wrote in the state constitution that all men are born free and equal, with the intent of eventually having the courts destroy the institution of slavery via judicial review. It was very good, and it worked. Indeed. All right, so it is not really difficult at all to see why the people of the Commonwealth do not wish to get rid of that Constitution of 1780, the oldest continually functioning constitution in the world that is written down. Okay, did you know that? Now you do. All right, so the Supreme Judicial Court held that slavery was incompatible with the state's constitution, the state constitution's declarations of liberty and equality before the law. Very important. With no distinctions based on race. All men are born free and equal. All right? Read the Massachusetts Constitution if you don't believe me. This was written in an era when each constitution of the original 13 states had to stand on its own feet. It was not a sub-document to some superior, primary document like the current U.S. Constitution. That didn't exist yet, all right? The Massachusetts Constitution boldly proclaimed freedom and legal equality, regardless of race, before the law, okay? So, now that I've got that out, I'm sure, you see my passion. I love Massachusetts. I love the history of the state, John Adams, all of it. Very, very, very wonderful history for Massachusetts. So, Quock Walker, ladies and gentlemen, was a Massachusetts slave, all right, born in 1754, all right, who was owned by James Caldwell, all right, and Mr. Caldwell died in 1763. So, his widow married another individual named Nathaniel Jennison, okay, and this is where it starts to get interesting, okay. So, under the laws, he became the property of Jennison, all right. So, Walker would flee his bondage in 1781 at the age of 27, and he found refuge in the home of Caldwell's sons, okay. Unfortunately for Quock, he would be recaptured and severely beaten thanks to his escaping the bondage. And with that action, litigation would begin, okay, for Walker to obtain his freedom from Jennison. And this would, ultimately lead to 3 separate cases, all right, all based around, Quock Walker, all right. So in the first case, Mr. Walker obtained legal assistance from prominent attorneys Lincoln and Caleb Strong, okay, and sued Jennison for assault and battery, all right. Now, he claimed that he had been injured without right, and it's a very important statement because apparently there were circumstances where such a beating would be justified. Okay, but Walker claimed he had been beaten without right. He argued that Caldwell, his initial owner, had promised him freedom upon reaching the age of 25, and that was obviously something Jennison didn't honor. Okay, so a jury here in this case in the Worcester Court of Common Pleas, would rule in Quock Walker's favor, finding that he was a free man and not the Negro slave of Jennison, okay? As such, he was awarded 50 pounds in damages, okay? So that's the first case. In the second case, this lawsuit was initiated by Jennison, okay, against Caldwell's brothers for interfering with his slave property, Quock Walker. Jennison argued to the court that Caldwell's brothers had illegally enticed Walker to escape his bondage for their own personal enrichment or uses or whatever the case may be. So, ironically, in spite of losing Walker in the first suit as a slave, Jennison would prevail here and was awarded 25 pounds in damages. Okay. Not surprisingly, both sides would appeal these contrary verdicts, okay? And they were accepted for review by the state's Supreme Judicial Court. I love that name, Supreme Judicial. Why couldn't our state Supreme Court be named Supreme Judicial? At any rate, both cases were accepted by the Supreme Judicial Court in 1781, all right? Jennison, however, did what a lot of individuals do and, did not present the required paperwork with his appeal. So as a result, Caldwell brothers would prevail by default. You like that, don't you? Okay? So Jennison, in failing to provide his paperwork, lost the case automatically, all right? And Levy Lincoln, who was one of the Caldwell brothers' attorneys, had strategically argued, even though, ultimately led to the victory, even though it was ultimately in default against Caldwell, Levy Lincoln argued, the provisions of the state constitution that guaranteed liberty, as well as arguments attacking slavery as a violation of natural law. Okay? So, it's nice that he put that out there, even though it seemingly appears that he didn't have to, because Jennison didn't file his appropriate paperwork at all. So that's why they won by default on the side of the Caldwell brothers. All right? So that takes us to the third case, ladies and gentlemen. In the third Quock Walker case, known as Commonwealth versus Jennison. Okay, so you see this is obviously a criminal matter. Jennison himself was indicted in September of 1781 for criminal assault and battery on Quock Walker. The suit that was initiated by the Attorney General of Massachusetts took nearly 2 years from filing to reach the Supreme Judicial Court. All right? Not until April of 1783. I was only 10 years old at that time, so you know. So in the meantime, Jennison petitioned the General Court of Massachusetts, which is their name for their state legislature, all right, in June of 1782 for reinstatement of the case that he had lost at the Supreme Judicial Court by default. Accordingly, the legislature did not act on his petition. Wah, wah, what a surprise. So in Commonwealth versus Jennison, all right, you see the Commonwealth of Massachusetts is the plaintiff and Jennison is the defendant. Supreme Judicial Court Chief Justice William Cushing, all right, a very prominent jurist, more to him later, would in his charge to the jury state that slavery was entirely incompatible with the state constitution of Massachusetts. His charge went as follows. These sentiments that are favorable to the natural rights of mankind led the framers of our constitution of government, by which the people of this commonwealth have solemnly bound themselves to each other to declare that all men are born free and equal, and that every subject is entitled to liberty, and to have it guarded by the laws, as well as his life and property. In short, without resorting to implication in constructing the Constitution, slavery is, in my judgment, as effectively abolished as it can be by the granting of rights and privileges wholly incompatible and repugnant to the state constitution. All right? Therefore, the court are therefore fully of the opinion that perpetual servitude can no longer be tolerated in our government, and that liberty can only be forfeited by some criminal conduct or relinquished by personal consent or contract. And it is therefore unnecessary to consider whether the promises of freedom to Quock on the part of his master and mistress amounted to a manumission or not. End. Okay, so ultimately, the jury would convict Jennison, and he was fined 40 shillings. So, that concludes the 3 Quock Walker cases. All right, now to the legacy. All right. So with Commonwealth versus Jennings in 1783, all right, slavery virtually lost all of its legal support in Massachusetts. Slaveholders realized from this case, the other Quock Walker cases, as well as the Brom Bett case, upon which, this arguably was a precedent for, these later cases. The Brom Bett case is covered in a separate video and was a precedent for the result here in Commonwealth versus Jennings and the other related suits here. The slaveholders realized that the state courts would not uphold the peculiar institution, slavery. All right. And for the remainder of the decade, the institution essentially died out on its own in Massachusetts. In the 1790 federal census, no slaves whatsoever were recorded in Massachusetts, making it the only state to have that honor. All right. Thus, Massachusetts became the very first, like I said, American state to do away with slavery entirely. Okay. Though not by statute or by a constitutional amendment, but by the effects of adverse litigation. Okay? So, to our players here in this case, or in these cases rather, William Cushing, who I mentioned above, who was the Chief Justice of the Supreme Judicial Court of Massachusetts, would be selected as one of President George Washington's original appointments to the Supreme Court of the United States in 1789. All right? And upon taking office in 1790, Cushing served on the Supreme Court for the next 20 years and 11 months until his death in 1810. All right? Making his service the longest of all of the Supreme Court's original members. Die hard. All right? Now, die hard victory right there. And as for Mr. Quock Walker, after all of this was said and done, he would later marry and settle in Barre, Massachusetts. Bar, Massachusetts, however it's pronounced. Not much is known beyond that with respect to the rest of his life. And he is reported to, however, unfortunately have died before the year 1810. So, he didn't live a whole heck of a lot, longer after this lawsuit. But, for the remainder of his life, remaining 30 years of his life or so after this lawsuit, he was a free man who married and raised a family and was almost certainly a positive and, prosperous member of the society in which he lived in Massachusetts. Okay? So this is the Quock Walker Cases, 1781 through 83. All right? And if you have any questions or controversies, you can leave them down below. I'll be happy to answer them. All right? If you learned something from this video, gained some insight here, drop me a like. All likes matter, folks. And last but not least, if you've not subscribed to my YouTube channel as of yet, if you've made it this far in the video, I'd really appreciate it. You obviously must have liked it. So I invite you to please subscribe to my channel. Just hit that little red subscribe button at the bottom right and we'll be in business. Thank you all so much for listening. All subscriptions matter. All likes matter. All right? I appreciate you, and your support means more than you'll ever know. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.